Good morning, folks. Busy day, 3 hearings on issues that are important in foreclosure cases across the state. In the first case, the plaintiff had obtained a final judgment of foreclosure, and in fact, the foreclosure sale had been set based on their allegations of a lost note. The plaintiff alleged that they lost the note. They swore to the court that they had made a diligent effort to locate the note but couldn't find it, and then the court granted summary judgment based upon those affirmations by an attorney or by a party in the case. The problem is, when I look closely at the alleged lost note or the copy of it, I found that this was not a note at all. If you'll look very carefully at the statutory definition of a note and what is required to reestablish a lost note, you'll find it's a very narrow definition. Many times the agreements that they're trying to reestablish through lost note do not meet the statutory definition of a lost note or a negotiable instrument that can be reestablished. So you need to look carefully anytime lost note is pled. Also, it's interesting to note, I published earlier in the week that MERS, Mortgage Electronic Registration System, had said that they don't favor the process of affidavits of lost note. So question anytime you see lost note. The second case involves a situation where they had moved for summary judgment, alleging that the plaintiff was entitled to enforce a mortgage. Problem was, the assignment of mortgage that they entered in the case had assigned the mortgage in question to a third party. When I brought that objection to the plaintiff, the original assignor then just assigned that mortgage to the plaintiff. They thought they had corrected the problem. What they didn't understand was that they had already assigned this to a third party. They can't correct that assignment by merely executing a new assignment to the correct party. They need to get an assignment from the party that they assigned that mortgage to incorrectly into the correct plaintiff name. Good luck tracking down that plaintiff who they assigned it to, or the party they assigned the mortgage to. The third case involves yet another situation of questionable endorsements and assignments, and again, the plaintiff had moved for summary judgment. The problem with these cases, and what presents in many cases that I see, frankly virtually every case, is that the documentary evidence and all of the evidence in the case file does not support summary judgment in these cases. Our judges are frankly too overwhelmed and too busy to catch all these errors. It's up to you pro se people and attorneys to get out there, bring these objections to the attention of judges, and stop these summary judgments that are being improperly entered. Have a great day. Keep up the good fighting.